this part of the conversation. And of course, we will be discussing discipline rather and dismissals, what's fair and what's legal, also things like the difference between misconduct and poor performance, substantive versus procedural fairness, and so much more. You certainly don't want to touch that dial. Hello, Elena.
Hello, Natasha.
How are you doing?
I'm all right. Thank you. How are you?
I'm good. I just want to ask you one question, okay? Now, you
Sure.
heard us talk about this whole respect thing. What is your take? Are you very much like, listen, please? Sort of why this particular topic in this week?
Sure. I'm really excited about the topics, the upcoming topics for the
Mhm.
rest of the month. We're talking about employment law, industrial law, labor law. Um, and the reason I think it's important is because to understand, we have to understand its importance in the broader context of employment relationships in South Africa. The core legislation that governs the relationship between an employer
Yeah.
and an employee is the Labor Relations Act. workplace, but that is not always the case.
Yeah.
What we're talking about is if there's misconduct, then it may in circumstances lead to a disciplinary hearing, which then may lead, if the misconduct is serious enough, it may lead to dismissal. And poor performance may also in some instances lead to dismissal.
Yeah.
But then the process is different. There must be a comprehensive performance management process or performance improvement process in order to dismiss that person. It's almost that person's behavior then becomes, or their incompetence or inability to do the work is more deliberate. We've done everything possible as an organization to accommodate the person, to train the person, but the person is still not coming to the party. And that could be for an array of different reasons. Maybe the person, just isn't intellectually able to do the work or physically do the work or whatever the case may be. But there must be a fair process. There must be deliberate engagement with that employee to establish whether the person is a fit for the organization. And I think one thing to remember is everything employee related is about relationship. So a relationship sometimes changes. So we may be a perfect fit today, but the organization might grow in a certain area and your skills need to grow alongside the organization. And so a lot of the time that doesn't happen. You don't equip yourself, you don't train, you don't do sufficient training
to stagnant.
To make sure that you are growing. And that sometimes happens with organizations too, right? Where the employee outgrows the organization, and so they seek alternative employment because they don't see there's growth capacity within the organization. So it really is a relationship that needs to be sort of weighed at every stage, of that relationship, and it can change. And what policies and procedures and what we're talking about does is gives a platform for that level of engagement. But I'm going ahead of myself. We will get there.
I love that you emphasized that employers usually sometimes the lines are blurred between on Facebook as well as YouTube, 0617981075. Janet Pringle on Facebook Live is saying, I'm listening on the radio right now. Thank you so much, Janet. And now I want to move on to the process of a disciplinary hearing, Elena. What does that look like in a practical sense? And I think these conversations are important because we need to know our rights, not just, of course, as employers, but also as employees. So just paint that picture for us when it comes to a disciplinary hearing.
So embarking a disciplinary hearing for an employer has different stages. So you have the investigation stage, you have the suspension stage, you have the actual disciplinary hearing where we're all now going to sit and we are going to discuss the matter, before us. So let's talk about that part of the disciplinary process, right? What are the essential things to consider when you are at a disciplinary hearing now? As the employer and employee, you must consider the notice. So there must be proper notice for that process to be fair. So the employee must understand what the charges are leveled against him or her. They must understand where they need to appear, and obviously they must be given enough time to prepare for the disciplinary hearing. They have the right to legal representation or alternative legal representation like a shop steward or a union rep or whatever the case may be, but they must be given the opportunity to solicit representation. There must be an impartial chairperson. A chairperson can form part of the organization as long as the chairperson can demonstrate that they are able to exercise objectivity when it comes to weighing the evidence. A a chance for both sides to be heard. There must be an opportunity to present both sides of the version. So employee must understand what's the charges, and they must be given sufficient time to respond adequately to all of the charges before that chairperson. And finally, there must be a reasonable outcome. So whatever the outcome is, there must be a justified reason for
Yeah.
that specific outcome.
Mm.
And usually that justified reason is found in your policies. In some cases, not all disciplinary hearings end up in dismissals. Some
Ah.
of them just end up in, a written warning or a final written warning or in demotion. The outcome in those instances can vary depending on the circumstances.
Mm.
And the same is true for a performance management process. The performance management process looks different
Yeah.
because there's constant engagement. The employer is engaging the employee on, how can we help you? What are the
Yes.
issues? Giving them the necessary training, and then giving them an opportunity to obviously apply that training over a period of time. That's why key performance indicators are
Yes.
important in an organization. But this is a lot more than the key performance indicators, because it's a lot more than just, meeting the target, but also training and equipping the individual to meet that target.
Mm.
And that's a process.
Yeah. There's so much to get into. And again, I like this part of the conversation because it's so relatable to so many of us. And so we're quickly just going to go to a bit of a break and then we come back and wrap up the conversation. So if you have any comments that you'd like to send through, I want to encourage you to do so on 061 798 1075. Remember, in as much as we see your questions, we won't necessarily answer them today, but we will have a Q&A session. And of course, we're also live on live with Elena Lievendal, L Inc. Incorporated, and of course, we are particularly talking about this week discipline and dismissals. What is fair and what is? We've just heard, of course, that there are different processes involved. We know that Elena spoke about, a dismissal, rather misconduct, as well as poor performance, and we also touched on when, or rather, when it would be, I guess, reasonable for one to be dismissed. And so she covered all of that. If you missed it, we were live on Facebook. In fact, we're still live on Facebook as well as YouTube. That's CCFM 107.5. I want to touch on number 4 just before we wrap up, Elena. Now, we know that there are some common errors or mistakes, I guess, that employers usually make, especially as it pertains to, things like CCMA cases. What are those and what do those look like? Because I think, again, a lot of us can relate, especially those listening, to say, I did not. It was not a case that needed to be taken to the CCMA. What can you say to that?
Um, so some of the big mistakes employers make is that they skip or they rush through these processes, and that compromises the integrity of the substantive fairness and the procedural fairness. Because remember, we spoke about this is a relationship you're talking about, right?